When you're dealing with custody disputes, you're already facing a set of challenges that you got to figure out how to navigate and overcome. But what happens now if one side has a blended family? That provides a whole new set of unique challenges that you need to understand, and hopefully this video will provide you some guidance on how to overcome that. For those who don't know me, I'm Sina Mohajer with Mohajer Law Firm. We specialize in family law, criminal defense, personal injury, and estate planning. In these videos, I like to tackle complex issues and try to simplify it for our viewers in order to give you the know-how and knowledge to be able to navigate through your case a little bit more efficiently. So if you like the contents of this video and you like what you hear, hit that like button and don't forget to subscribe so you're always informed of any new videos being posted. So without further ado, I welcome you all to our new mini-series called A Walk in the Park. So what are some unique challenges that you face in a blended family situation? Well, first of all, what is a blended family? And a blended family normally consists of a step-sibling, half-siblings, a step-parent, and the like, or even potentially even a co-parent, like a cohabitating situation. And some unique challenges that it provides is, for example, different parenting styles. It could be a division of loyalty, or it could have any type of conflict with the parenting or visitation schedule that you currently have. So what are some legal considerations that you should keep in mind? The utmost thing on the top of every list, regardless if you have a blended family or not, is what is in the best interest of these children. That's what the court reviews, and that's what you should be reviewing, is putting our differences aside and not worrying about the fact that whether you moved on or the other parent moved on. It's what's in the best interest of these kids. Also, what is the role of a step-parent if you have one in your particular case? Now, I've had cases before where I've heard judges specifically say that a step-parent has a vital role in all of this, but it's important that they don't overstep their role. And one way of overstepping is, for example, deciding when and how to discipline the children, dictating when visitations occur, or getting involved with co-parenting decisions with the biological parent, not their partner. A step-parent is important to be there as a support system to that parent, to help facilitate whether it's transportation or just being there to help out with custody and visitation issues between the two of them. But it's never a good idea for the step-parent to get involved with the underlying issues between both parents. It's important that they stay in their place and they understand their role. Also, half-siblings or step-siblings. It is important, and the courts want to see this, that we're nurturing the relationship and continuing that relationship, if there is one, between your children and the half-siblings or step-siblings. And it's important not to sever that relationship unless it is not in their best interest to maintain that relationship. So what is a strategy that we can kind of overcome these challenges? One method, and I can't emphasize this enough, is having an open line of communication. But not just an open line of communication, but in a respectful manner. Because you have to realize you're co-parenting with your ex-partner. It's important to keep the lines of communication open, honest, and respectful. You'd be surprised of how much you can accomplish if the two of you can just openly discuss issues that are concerning to you and figure out ways to overcome those issues. Now, if communication doesn't work, you always have the ability to go seek mediation. And in mediation, you're going to have a third-party neutral hearing both sides and help facilitate an agreement if one can be had. If mediation doesn't work, also you can look at detailed parenting plans. Now, a detailed parenting plan technically can come from mediation or even open lines of communication, but a detailed parenting plan is going to set the rules. The more detailed you can come in a parenting schedule, the less conflict potentially you're going to face. But if all else fails, you always have the right to seek court intervention. And sometimes, unfortunately, that's the only option left because it takes two to tango. When you go to court, the court's going to look at what's in the best interest of the kids, and they're going to dictate exactly how the parenting schedule is going to happen. But I don't want you to worry or stress out over what if you don't get the right order, because in family court, you can always modify a custody visitation order. If there's a change in circumstances or things occurred that it's just not working out for the kids, you or the other parent have the right to go back to court and ask for a modification. So when you're dealing with court intervention, I can't emphasize this enough, that it's so important that you consult with a seasoned family law attorney. There are so many nuances and loopholes or ways to argue things. To increase your likelihood of success, you're always going to be better fitted having a seasoned family law attorney in your corner. So if you have questions about your case, I welcome you to call our office to schedule a consultation. I'm happy to sit down with you one-on-one to discuss your case in more detail and figure out the best approach to take. And if you like the contents of this video, hit that like button and don't forget to subscribe so you're always informed of any new videos being posted.